So welcome everybody, also in the name of Marta, if I may say, and sorry for the delay, but you realized that we had some internet problems. Everything is solved now. We are live on YouTube, and there will be a video also from later on on this conference. So I'd like to welcome, if there are people, also the people watching on YouTube. My name is Tietje. I'm a professor of European Union and International Economic Law at the University of Halle. You saw my colleague, Anne Mittwoch. She was in her office at our university back in Germany. We are here for this conference and also tomorrow and the day after for a PhD conference, which we are also looking forward very much. This is a joint effort, this conference, of many people, of course, but foremost of the Addis Ababa Law School and the John Monnet Chair for value-oriented neighborhood and trade policy that I have back home. So we are thankful, first of all, of course, and it's essentially a conference of the Addis Ababa Law School, as you know, and Professor Marta and the Dean. Thank you very much for the cooperation, of course, again. And secondly, we are also thankful for the European Union, that is giving some financial support for today. I'd like to thank also all the other staff that made able this conference. Let me say just a very few words on substance. We just heard from Professor Anne Mittwoch how important but also complicated capital market regulation is in the European Union. We are here in Ethiopia. We have many challenges ahead, but one thing is clear, and I don't have to tell you because you know about it. Capital market regulation is key for economic development and prosperity, but it is also dangerous as instability, that is to say problems in capital market regulation, as instability in capital markets may cause significant financial or economic crisis. We all know that as we remember the global financial crisis of 2007-2008, which at least to a certain extent was based and had its reason and origin in a failure of certain aspects of capital market regulation. The capital market regulation is, of course, foremost domestic, an issue for domestic regulation by the respective national legislator and the enforcement authority, the supervisory authority. But it has also an international dimension, and myself, I'm not a specialist in domestic or European Union capital market regulation, but I do know a little about international aspects of capital market regulation in two perspectives. One is, of course, the liberalization of capital markets and finance via the General Agreement on Trade and Services and respective free trade agreements, the African Continental Free Trade Area and agreement we have here is, of course, of significance in this regard. And the second aspect is investment protection and investor-state arbitration, because we have increasingly interdependence of international investors and capital markets and domestic capital market structures. Just a few numbers out of the more than 1,000 cases that have so far been registered with the International Center for the Settlement of Investment Dispute arbitration cases. Worldwide, there are more than 1,600. Out of these cases, 7% are concerned and were concerned with financial services, that is to say capital markets. Just one recent example, you might know and remember that in Switzerland in 2023, the Credit Suisse, one of the biggest banks in the world, ran into troubles, economic troubles, and by a state regulation of the competent authority, UBS, another big Swiss bank, was forced to merge and take over Credit Suisse. This was a huge merger. It was based on considerations of stability of capital markets in Switzerland in this regard. And there are already at least 6 investor-state arbitration disputes being announced towards Switzerland. We'll see where it goes, but at the end it might cost this movement for stability of capital market might cost the Swiss government a lot of money for several reasons. There are, of course, also increasing number of respective cases in Africa, namely in the sub-Sahara region. And for Ethiopia, you probably are all aware about the case of African Asset Finance Company Holdings, AAFC, and Ethiopian Capital Goods Finance versus Ethiopia. I don't know whether you followed that case or know about it. Just as a background for everybody, the claimant in that case is a Dutch entity, AAFC, and a respective subsidiary, and they challenged the National Bank of Ethiopia's regulatory shift from a dollar-linked to denominated leases, arguing that this move destroyed their business model. The tribunal, and the decision has just been released in April, so about a month ago, a bit more than a month ago. The tribunal rejected those claims. At stake were more roughly 350 million US dollars, and the tribunal rejected. Ethiopia, so to speak, won the case and argued that there is no, and the tribunal found that there was no expropriation or violation of fair and equitable treatment in this regard. The case is seen, it was a victory, so to speak, for the government. It was seen as a ruling that affirmed the state's regulatory autonomy in the financial sector. But it shows also, even though in this case the government won, the case was rejected, it shows the danger, so to speak, how sensitive capital market regulation in different aspects is, because not only Ethiopia, but many countries in the world have a very close net of bilateral investment treaties and other regulations on investment protection. And any regulatory move on the capital markets may cause cases under these respective legal regimes. That is all I wanted to say. Thank you very much again for joining today. And I hand over to the Dean, I guess, for welcome, please.